Hello everyone. You missed your immigration court hearing and you are ordered removed from the United States. What are your options? What are you going to do? This is a question we get a lot. Now is the time for me to finally break down what is involved and what can happen and what are the potential remedies. Bear with me. Let's get to it. First of all, I should start with some brief context as to what the immigration court proceedings are. Removal proceedings are where the government is trying to argue for someone's removal from the United States. There is an individual hearing where this removal relief is basically, it's essentially a trial where your argument is discussed, and before that there's a procedural hearing, a master calendar hearing where your situation is discussed. Usually the one you miss is a master calendar hearing. If certain conditions are met, the government can have you ordered removed from the United States in your absence. Now, to do that, there are certain conditions that must be met, and the first and foremost, quite logically, simply, you need to know about this court date. The due process, our Constitution says, you're supposed to be informed of this court hearing, otherwise they cannot order you removed. Even if they do, you can file a motion to reopen, which we will discuss shortly. So, first of all, you need to know about this hearing date. How do you do that? How do they make sure that happens? The first step is by serving the NTA, notice to appear. So the NTA is usually served in person or sometimes after a proceeding. The court date on the NTA is crucial, and they usually try not to change that court date so that they don't have to serve you again. They don't have to keep you updated about the changed court date. So you get a notice to appear, which starts the court proceedings, and there's a court date there. If that notice to appear, NTA, is served to you properly in person or through mail, then if you miss that court date, you will probably be ordered removed from the United States. Now, what's important is the arrangement about mailing. So there are certain regulations that specify how you should be informing the government about your change of address. That's why there are a bunch of forms that they make sure that you provide your address, and you are responsible to provide your current up-to-date address if you change your address, and that this is one of the requirements. So informing someone about the upcoming hearing goes directly hand in hand with the address requirement. So if you change your address properly, if they try to mail you, serve you this at a wrong address, then that makes it a very strong argument to be able to get this motion to reopen approved and reopen your court case, and then you have another shot. Now, another thing to consider is lack of notice is a very common and very strong way of arguing. But on top of that, there is also an exceptional circumstances argument. To this one, there's a deadline. You're supposed to be filing this within 180 days. If you don't file within 180 days, you're supposed to argue for something like equitable tolling, something that prevented you from, making this motion. Otherwise, it's supposed to happen within 180 days, and there has to be exceptional circumstances. I'm not talking about a basic, inconvenience. It has to be a serious circumstance, a serious health situation or a family member's health situation or life or death kind of situation. Unfortunately, those are the only ones that qualifies under this standard. So lack of notice, exceptional circumstances. Now we're going to fall back on the least desirable one, which is a discretionary arrangement, something we call a Sua Sponte. I call it the least desirable because it is not something we can argue. Basically, we are asking the immigration judge to exercise discretion and reopen the court case. There is no legal argument here. So it is up to the immigration judge to exercise discretion or not, to empathize with your circumstances, to sympathize with you and, find it in their heart to exercise discretion. And unfortunately, with the new administration coming in, this is unlikely to happen. We used to utilize Sua Sponte motion to reopen quite a lot, but unfortunately there's pressure on immigration judges. Immigration judges are unfortunately not Article 3 or Article 1 judges. They do not have job protection. They are employees of the government, Department of Justice to be specific. So they have standards to abide by. It doesn't mean that their specific decisions are going to be scrutinized, but they are under indirect pressure to order in a certain way. So they indirectly, they want to keep their job. They don't want to look bad. and they are less inclined with this administration to exercise discretion and grant these Sua Sponte motions to reopen. Obviously, motion to reopen is a very technical area of immigration law. I cannot break down. I can talk about it for hours. A simple video is not enough. Today we just wanted to focus on in absentia, motion to reopen that's going to apply for a removal order that is entered during someone's absence, when someone did not appear. Obviously, there are ways you can also try a motion to reopen after there is a removal order entered when you attended the hearing, when you argued and when you lost. Maybe you lost an appeal later, maybe you didn't appeal. That is another day's topic. But for now, if you think you can benefit from these arguments, you think you can argue, there's some of these apply to you or someone you know, reach out. This is very technical. We have to evaluate your circumstances. We usually end up filing for a copy of the immigration court case and to specifically understand what happened. What was the hearing date that was missed? What was the type of notice that was provided? What was the address there? Was it served in person, etc.? We do a detailed assessment first to understand if any of these topics apply, and worst case scenario, we might be able to win with a motion to reopen that's Sua Sponte by asking the immigration judge to exercise discretion. So you don't lose anything. It doesn't hurt to try and look into your circumstances, because even if one of the legal arguments are not there, we can always try Sua Sponte and try our luck. Unfortunately, right now is not a position where you can be comfortable if you have a removal order. You have to take action. Right now, ICE is cracking down on those with a criminal history, with a criminal involvement first, but the time will come to those without a criminal involvement. They are spending serious money to increase their capacity to detain people, opening up new detention centers all around the country. So now is time to take action. In 3 to 6 months, everything could change drastically. Keep in touch, keep watching us to be informed, and feel free to reach out. Our contact information is right here in the description of the video.